So how do officers exceed the scope of consent? Consent's limited to particular area. So if somebody says, you can stand here, but you're not coming in here, and an officer exceeds it, we know that that consent's not going to be valid. That's an easy one, but it's something that we shouldn't overlook. They also can't pull a person out of the premises. In that hotel case that I kind of did the introduction for, they pulled my client out of the hotel room at that point, and that was where the whole search went bad. I've seen on television, people, not television, on like YouTube, when lawyers do these like videos. I'm a public defender, so I don't make videos and put them on YouTube, but sometimes private lawyers do. And people saying, well, you should go, if you want to talk to the police, go outside. What's the problem with that? Well, there's a lot of problems with that. But what's the real problem with that? To go outside, you have to open the door. And when you open the door, the officer can put his little eyeballs inside your house. So close the door. And there's some case law that tells us if you close the door behind you, you're better off than if you leave the door open. Because if you close the door behind you, then the officer can no longer see in. But if you're just holding the door open while you're talking to Officer Skippy, then he can look inside. So, and that creates a plain view situation. We're not going to talk a lot about plain view. The only thing I want to say about plain view is that the officer can't create a situation. Remember, a lot of times people say, well, they opened the door and they could see inside, so that's the end of it. It's plain view. It's like, no. Because if the officer does something that he's not allowed to do in order to create the plain view situation, it's still a bad search. And we're going to see this guy do it right now.
Don't tell me what I can and can't do.
This is my residence. You can't
there
step
he
foot in
goes.
my house.
Yes, I can.
No,
right?
you can't.
I'm going to put my foot here
Okay.
so you can no longer close the door.
Yeah.
So just remember, plain view is not the end of it. The exigency cannot be created by the officer. So you want to consider also the way doors work. Right? I told you I was going to talk for an hour about knocking and doors. Because you want to consider the way doors work. And this is really important. I had, in that hotel case, the officer said when he opened the door, it was just open, and they were standing there and talking. You guys all left your hotel rooms this morning. Did your hotel room door stay open? No, those things slammed shut. Mine almost killed me this morning when I was on my way out the door. And we had to have a maintenance person from the hotel come in and explain how the hotel door worked, right? So you want to think about how doors work, what way they open. Do they open in or out? All those things could be important. And the best advice to clients, if they're knocking, don't answer the door. Nobody can get into trouble. If they have a warrant, they'll come in, right? All right. So let's take a moment for knocking. I just want to check how much time I've got. Oh, I got 20 minutes. I'm from New Jersey, and then I talk fast when I get nervous, so it's like, wow, look, I've got 20 minutes. So let's take a moment for knocking. This is from an actual police Facebook post. And if this is an officer in your jurisdiction, you're going to want to keep that, but this is not about social media. So we want to remember, these are warrant searches. So I'm going a bit astray from consent searches, but since knocking is in the title, I felt a little licensed to do this. Knock and announce. We want to remember that there's 4 things that have to happen in a knock and announce. The officer has to identify themselves, verbally demand entry, give the occupants information about the scope of their authority, and give the occupant an opportunity to answer before they force entry. So that kind of goes like this. Police, open up, we have a warrant. And then the guy with the battering ram stands there waiting because he's excited. Because soon he might get to swing it. And how long does little Sparky have to wait? All right, so 20 to 30 seconds is sort of the range, depending on your jurisdiction. In New Jersey, we get like 30 seconds. Like, it depends. 20-second US versus Banks, 20 seconds was a close call, but okay, and it's a totality of the circumstances test. So we need to think about showing the judge that a longer period of time was what was reasonable. Layouts of homes are important here, but don't think of layouts as flat. Think of them as 3-dimensional. So a layout of a home from the side is a cool way to show this, because what if I don't know if this has a pointer, what if our person, the door is where that tree is, and our person is where the pink bed is? It's going to take a long time for them to make their way down the stairs and get to the door, right? So if you have a large home, maybe you want to show the proximity between where your client was and the door. And you can find these things, like I'm in the middle of redoing my living room, and I'm on all these sites where you can like make diagrams of your house on Raymore and Flanagan and stuff. Use that stuff. It makes great diagrams of houses. You move the couch here, it'll be a Raymore and Flanagan couch, but who cares, right? Move things around. Video. You want to look around for video, not the officer's video, other video. Everybody has a video camera. The first clip I showed you was some guy's Ring doorbell camera showing police officers knocking on what turned out to be the wrong house. They went in later, that's the whole thing. I just like the board knocking. But you wanna get surveillance. You wanna get any information that you can about any other visuals you can other than the police officer footage or the police officer report. And what I'm going to show you is a video. This was a case that happened in New Jersey very, very recently. My significant other is also a criminal defense lawyer. This was his case. And the police officer in the police report said that they waited 30 seconds. They waited 30 seconds before breaking down the door. The officer gets on the stand. Officer testifies that he waited 30 to 45 seconds before knocking on the door. What he didn't know is that the attorney in this case had done these things, had pounded the pavement, interviewing people, and found a camera. Right? Sparky was excited, right? He went right in. So this, and of course he won the case got dismissed, but that's not the end of it. And I think the really important message that I want to give you guys is don't let that be the end of it. When you see an officer has done something like this, you have got to tell other lawyers. And so what he did was got permission from his client to send a copy of the video, the transcript, and the police report to the public defender's office, to the local ACDL, to the presiding judge, to the chief prosecutor, to the police databases that were maintained by the nearby office, and to the press. He also sent it to the police department and asked them to do an investigation.
Search incident to arrest, right? That's the kind of legal issue. I mean, we all kind of know that, you know, if there's an arrest, you are probably going to be searched. But here's a lot of things that we forget, right? Is that there are limits, right? And so if there are no officer safety issues or no evidence preservation issues, there's nothing within the immediate control of the person who's being arrested, then there should be no search. Let's jump back into this hypothetical, right? Did you guys see any officer safety issues? Didn't see any, right? You know, did they have to preserve the evidence? I didn't see the evidence that needed to be preserved in the hypo that we saw here and that the officer was able to see. Now, we know there's drugs in the trunk, right? We're going to talk about that. But again, as you're thinking through these things, you know, you're looking at your facts and trying to figure out, you know, where can you draw the line? It's so important in the motions to suppress to be able to draw the line to say this is when the search stopped. And the brighter that line you can draw, the better you are. All right. And then, yeah, you know, the lawyering piece that this part of the hypo brings out is, you know, you got to go and recreate this scene because this is just some BS. Let me get this straight. You all saw the scene, right? He's in a residential area. So how could he ever be drawing 55? And where is a 54 mile an hour? Like, I mean, I've never seen a 54 mile an hour speed sign, right? Speed limit sign, right? So you got to go back out there and just kind of like lay that lie bare, right? And so again, in every single motion to suppress on traffic stop, you know, go out there, video it, obviously interview the witnesses, recreate the scene to the extent that you can. And that's why I always go back to my boy Jay-Z saying, look, you know, I got a lot of dollars, I can fight the case because this is a lot to do. All right, license and registration, step out of the car. What legal issues that bring up, right? That's just basic. Look, they can ask you to step out the car for officer safety issues, and again, it's as long as the intrusion is de minimis. But the lawyering issue here, particularly on this hypo, is what is so important, right? If this is just a traffic stop, and that's what our hypo showed us with Jay-Z and his boy Rick Rubin, why is he being asked to step out of a car, right? That's a bridge too far, certainly under the law. One of the things, too, that I think help you argue that is you've got to grab the standard operating procedures for whatever police department you're in, right? Or the general orders. And oftentimes you'll be able to see, look, if this is just a routine, mundane, garden variety traffic stop, then there's no reason for the citizen to have to step out of the car, okay? And so if, this officer's asking Jay-Z to step out of the car and violated, his standard operating procedures, then that's something, that's something that you can work with, all right? All right, well, what is that? That's just, when the officer says, look, are you carrying a weapon on you? I know a lot of you are. That's explicit bias, that's implicit bias, right? But, there's this issue of Terry versus Ohio, and as you all know, what is this, 2018, and Terry came out in, 1968, right? So it's 50 years. And as lawyers far more talented than myself have argued for a long time, reasonable articulable suspicion was created in Terry in 1968, right? Where the country was a pretty chaotic time. But that standard, right, has been used to justify all manner of racial profiling, right? I mean, it's a bad law. It's one reason why I say we got 99 problems, but the law ain't one, because, it's so difficult to win on our side of the ledger when you're dealing with reasonable articulable suspicion, because what's reasonable articulable suspicion? The guy who's nervous, the woman who's in a drug trafficking corridor, strong air freshener. I mean, these are all reasons to stop someone, and you'll see in our briefing, this is what the cases say. And then even race plus another factor, right? So, the law is terrible on reasonable articulable suspicion, and it's another reason why I say to win these motions to suppress, you want to get away from that and be able to argue, look, this police officer can't be believed. All right, and then look, the officer kind of accusing Jay-Z of carrying a weapon. I mean, we know about that implicit bias. We've talked about it. What are the legal issues there? Okay. Officer asked, look, you mind if I look around the car a little bit, right? So this gets to consent. And, the legal issue there is, obviously, is the consent voluntary, non-coerced? That's easy. But when you start looking at issues of implicit bias and you start dealing with consent, there are judges around the country who are starting to get that things like race and consent really matter. And so this is Judge Vasquez in a case out in the District of New Mexico. She's a former public defender. And in her ruling in a suppression motion hearing, this is what she says. She says, listen, given the backdrop of fear between people of color and law enforcement, the court must consider race as a factor. So I'm just repeating what Al Minister said earlier, that, you've got to start putting these bias issues in front of a court so that you can give a court license to go ahead, as she did in this case, and suppress evidence. All right, so if you're dealing with consent in a motion to suppress, right, the question is always going to be, do I put Jay-Z on the stand? How many people put Jay-Z on the stand? Show of hands. Because I put Jay-Z on the stand. That's Jay-Z, right? But the analysis, right? The calculus is, well, okay, look, if my client testifies in a suppression hearing, probably we'll have immunity. The cases are really good on that. But if he testifies in the actual trial, will he be impeached? For those of you who do sentencings, because your clients get convicted, you got to deal with whether what your client said at the suppression hearing can be used against him at sentencing, and particularly on the federal level. In some, I think, over-the-top U.S. attorneys' offices, will your client testifies, that's going to be an obstruction of justice enhancement under the guidelines, right? And then obviously, if your client's going to testify, you're going to have to prep. You have to work with Jay-Z for a little bit, make sure he's ready to handle cross-examination. And then here in New York, as I understand it, if your client takes the stand, you got to file an affidavit first. So that's another, obviously, kind of legal strategy thing you need to think about when you're thinking about the lawyering piece of this.
So now I want to show you kind of what the central argument of our motion was. Our central argument on discriminatory effect was that, the report that Jeff Fagan had written provided this evidence of similarly situated people being targeted not to the same degree as people of color. That was the evidence that had been missing from Armstrong. That was the evidence that has been missing from every case since Armstrong, basically. And I said, we've proved that, right? Because what Fagan showed was there were similarly situated white people available to be targeted, but the ATF just didn't go after them, okay? So I have this chart in my motion. It's a little busy, and I'm sorry it's probably a little small, but I can explain to you what it says. Basically, look at figure 1, the 2 columns on the left-hand side. That was what I said to the court. This is my comparative evidence that I am bringing to you, okay? Looking at the far left column first, look at the defendant group. It is 78.7% black, okay? That was my group of clients. And then if you look in the second column over, the comparison group was 55.4% black, right? So what Fagan found, as you see right below that, is that the likelihood that such a racial composition, such a high proportion of black clients would result from just chance was essentially 0%. What does that mean? Discrimination, right? Okay. And as you see from figure 2, my big point with this figure 2 was, if you look at Armstrong, they didn't have any comparative evidence. That was what was missing in Armstrong. That was what they fell on, if you read the Supreme Court's opinion. And I said, judges, we have brought you that comparative evidence, and it proves discrimination. So all of this is just, what I've just given you here is, this is a summary of our evidence of discriminatory effect, prong 1, okay? I'm gonna get a little bit into prong 2 now, just to give you a sense of discriminatory intent, because we have to do both, maybe, because asterisk that, we've got some good law. Okay, so the Fagan report also provided evidence of prong 2, the discriminatory intent prong. Professor Fagan, in brief, conducted 3 regression analyses where he ruled out race-neutral explanations for the disparity he found. So he controlled for demographic variables, he controlled for criminal history variables, and he said, any way I look at it, any way I slice and dice it, I'm still coming up with, this is, you know, statistical evidence of discrimination. He said, this stark racial disparity cannot be explained on grounds other than race. And he said, ultimately, these analyses show that the ATF is discriminating on the basis of race in selecting stash house defendants. So beyond this Fagan report, we also, in our motion, provided some additional evidence of the idea that the ATF had intentionally selected our clients on the basis of race. We included this chart. You don't have to be able to read this chart. I just want you to look at the red blocks, okay? This was a chart of all the clients who the ATF had ever gone after. And right here, you're looking at a chart that is just focusing on some of the black clients, okay? This chart shows that the ATF deviated from its internal criteria when it went after people of color, okay? So the red blocks here, that's the deviations. Now, in the very few cases where they went after white people and where they targeted white people, they scrupulously adhered to their criteria. You see the difference between this and this, okay? And what we said was, we used this Supreme Court case to say that these racially skewed departures from the ATF's own criteria established discriminatory intent, okay? And then we also had this crazy evidence. In some of the cases, the ATF expressly recruited black clients on the basis of race, okay? Because the agent claimed to be Mexican and working for a Mexican cartel, but he would essentially tell his black targets to recruit other black friends, okay? So what he said was, I said this is from my motion, the agent made clear that the race of the robbers was important and they couldn't be Mexican. That's why I'm coming to you, you know, I roll with my cuz, but this shit can't come back on me. You know, if they see other Mexicans doing it, they're gonna know they're with me. You know what I'm saying? So basically like telling the guy, don't bring me anybody who's not black. Okay, really screwed up, but part of our evidence of discriminatory intent. All right. So one of the biggest victories that came out of this stash house litigation that I'm telling you about is something that we can all use on all different kinds of race-based litigation, okay? We changed the law in the 7th Circuit and elsewhere in a way that makes it a lot easier to get discovery on a claim of racially selective law enforcement, okay? So I want to go through this with you. I litigated this one appeal because the government appealed a good discovery order for us. They appealed it. I won on jurisdictional grounds in front of the panel, and then they, of course, tried to take it en banc. I did the en banc oral argument, and the ultimate result of the en banc opinion was very much in our favor. The Seventh Circuit lowered the Armstrong discovery standard specifically for claims of selective law enforcement, meaning when you're saying that the police or the agents are racist, they sort of distinguish them from the prosecutors, okay? So what the Seventh Circuit did was they drew this clear distinction between these two kinds of claims, selective enforcement and selective prosecution. And they said that that terrible Armstrong rule just doesn't apply when you're trying to get discovery about racism by the police or by the federal agents. They said, some of the discovery asked for information from supervisors or case agents of the FBI and ATF, and this is outside the scope of Armstrong. Can you imagine how exciting that is? Outside the scope of Armstrong. Like, Armstrong's the thing that always kills this stuff. So, whoa, that was super, super amazing. So the even more amazing is the Third Circuit and the Ninth Circuit have now followed suit and gone further than my Seventh Circuit. And they've made this law even better for all of us. So anyone litigating in those places, you've got great law. Anyone litigating anywhere else, you can build on this, you can make better law in your area, right? So first, let me tell you about these cases, okay? What did they do? How did they lower the bar for getting discovery about selective law enforcement?